With regard to the duty to explain, again, you cannot simply provide a client with a copy of the lease and say, read it. It's important that we identify our estates department or whoever's instructing us as objective with regard to the transaction, and that we provide a report determining whether that objective is going to be achieved, and explaining to the client, the estates department, or whoever's instructing us, the key features of the document that we have drafted or that we're advising. We can't just lazily say, there's a copy of the lease, read it. If you're acting for a landlord, before the lease goes off to a tenant in duplicate, I would always make sure that my estates department has read it and considered it. I would also recommend the use of the RICS model heads of term, and also suggest that you are aware of the RICS code for leasing business premises, which is the subject of the next slide and what I want to talk about for a moment or two. The purpose of the code of practice is twofold. Firstly, to provide a framework with regard to commercial leases, to assist with regard to the parties that are negotiating terms or drafting a commercial lease, to act as a sort of an addition to heads of term. The RICS code for leasing business premises is good practice, and its use, although not universal, is quite commonplace, particularly with what I regard as sort of heavy commercial leases, where you've got a blue chip tenant or landlord involved in the transaction. The lease code highlights and emphasizes the use of heads of term, and it's the landlord's responsibility to make sure that where negotiation is taking place or indeed is concluded, that heads of term are utilized. With regard to heads of term, a lot of practitioners, a lot of lawyers suggest that they should not get involved in the negotiation of commercial leases. And I agree with that, other than to at least participate at a distance in agreeing heads of term. In other words, before heads of term are finalized, casting an eye over the heads of term to make sure that there aren't any problems from your side of the transaction that need addressing or highlighting. Let me give you some examples. If my estates department is going to agree that a tenant is going to be granted a lease of 15 years for, I don't know, a retail unit, that lease is going to require registration at the land registry. It may be that we have a problem with regard to the title out of which the lease is derived. The title may be unregistered, there may be deeds and documents that are missing, meaning that the lease is not going to be registered with an absolute title when it's registered. The Land Registration Act 2002 simply requires that the lease is registered, not that it's registered with an absolute title. Some tenants may insist that it is registered with an absolute title, I'll explain why in a moment or two, or the commercial conditions of sale might apply to the transaction, in which case there's an obligation on the landlord to ensure that the lease is registered with an absolute title.